You are building your entire American future on a foundation, and that foundation has a name, USCIS. And right now, thousands of immigrants are making decisions that are quietly destroying their cases, missing deadlines that cannot be recovered, and filing applications based on rules that no longer exist, simply because they do not truly understand the agency that controls everything. Not their visa, not their green card, not their work permit, not their citizenship. Everything. So if USCIS feels like a confusing, intimidating black box that holds your future but never explains itself, what you are about to learn in the next 12 minutes will permanently change how you navigate this system. Do not skip a single second. Welcome to Global Immigration News. Today we are doing something that most immigration channels never do. We are going to pull back the curtain on USCIS completely. Not just what it is, how it thinks, how it makes decisions, what it looks for in your application, what triggers a denial, what triggers an approval, and what you must do differently in 2026 to protect yourself inside a system that is processing millions of cases and has zero obligation to give you a second chance if you get it wrong the first time. Let us start with the one fact that reshapes how every immigrant should think about this agency. USCIS, U.S. Citizenship and Immigration Services, is not an enforcement agency. People confuse this constantly, and it creates unnecessary fear that leads to unnecessary mistakes. USCIS is a benefits agency. Its entire function is to receive applications from people who are seeking lawful immigration benefits and to adjudicate those applications according to U.S. immigration law. When you file for a green card, a work permit, a travel document, an extension of status, or citizenship, you are dealing with USCIS. The agency that arrests people, conducts deportations, and enforces immigration violations is ICE, Immigration and Customs Enforcement, a completely separate agency. The agency that stops you at the border and controls your entry into the United States is CBP, Customs and Border Protection, also completely separate. Why does this distinction matter so much? Because when immigrants do not understand who they are dealing with, they make fear-based decisions that hurt their cases. They avoid filing necessary applications because they are afraid of drawing attention to themselves. They fail to respond to USCIS notices because they fear that any contact will trigger enforcement. They delay renewals of critical documents because they view any interaction with the agency as dangerous. These decisions, rooted in a misunderstanding of what USCIS actually is, create the very problems people are trying to avoid. USCIS is the door to legal immigration benefits in the United States. You do not avoid that door. You learn how to open it correctly. Now here is the next thing you need to understand clearly, and this is where an enormous number of applicants have a gap in their knowledge that costs them real time and real money. USCIS is not the same as a US embassy or consulate. When you are outside the United States applying for a visa stamp, that application goes through the US Department of State, through the embassy or consulate in your home country. USCIS has no role in that process. But the moment you are inside the United States and you need to extend your status, change your visa category, apply for work authorization, or file for a green card through adjustment of status, that is USCIS territory. This boundary, State Department and embassies outside the US, USCIS inside the US, is one of the most fundamental pieces of information every immigrant must know. Because filing with the wrong agency or misunderstanding which agency governs your situation can result in wasted time, wasted money, and a lapsed status that creates serious consequences downstream. So what does USCIS actually control? The full scope is larger than most immigrants realize until they are deep in the system. USCIS processes the I-130, the family-based immigrant petition. It processes the I-140, the employment-based immigrant petition. It adjudicates the I-485, the adjustment of status application that allows eligible individuals inside the United States to apply for a green card without leaving the country. It handles the I-129 for non-immigrant work visa petitions, including H-1B, L-1 and O-1. It processes the I-765 for employment authorization documents, the I-131 for advance parole travel documents, the I-539 for change or extension of non-immigrant status, the N-400 naturalization application for U.S. citizenship, and the asylum application for protection-based cases filed from within the United States. Every one of these applications has its own form, its own filing fee, its own documentary requirements, its own processing timeline, and its own adjudication standard. And here is the point that changes everything. The rules for one application category do not carry over to another. What USCIS requires to approve an I-140 employment petition is fundamentally different from what it requires to approve a naturalization application. You must know the specific rules for your specific benefit, and you must build your entire case around those specific standards. Now we get into the part of this video that most people need to hear most urgently, because this is where cases are won and lost before applicants even realize it is happening. How does USCIS actually make decisions? USCIS officers are trained adjudicators. They are not making judgment calls based on gut feeling. They are applying a structured legal framework to the documents you submit. And that means one thing above everything else. Your application is only as strong as the evidence you file with it. An officer cannot approve a benefit that your evidence does not support. It does not matter how long you have waited, how much money you have spent, or how genuine your situation is. If the documentation in front of that officer does not establish your eligibility according to the legal standard that applies to your category, the case will not be approved. This is the reality that needs to reshape how you approach every single application you file with USCIS. Do not think of your application as paperwork you are completing. Think of it as a legal argument you are making. You are presenting evidence to an adjudicator and arguing that you qualify for a specific benefit. Every document you include either strengthens that argument or weakens it. Every inconsistency in your application, a date that does not match, a name that is spelled differently across documents, a job description that contradicts your tax records, introduces doubt into that argument. And doubt in an immigration application does not resolve in your favor. It triggers scrutiny, delays, and often a request for evidence. Let us talk about the request for evidence, the RFE, because how you understand this notice determines how well you respond to it. An RFE is not a denial, but it is not a neutral development either. When USCIS issues an RFE, the officer is telling you that the application as submitted is not sufficient to approve the benefit you are seeking. Something is missing. Something is unclear. Something does not align. You are given a specific deadline to respond with additional documentation or legal argument addressing the exact deficiencies the officer has identified. What you must understand is that your response to an RFE is one of the most consequential documents in your entire immigration case. It must be complete. It must be organized. It must directly address every single point raised in the notice. A weak or incomplete RFE response very often results in a denial. If you receive an RFE on any significant immigration application, do not attempt to handle it alone unless you have deep expertise in that specific application category. The cost of professional legal assistance at this stage is always less than the cost of a denial. More serious than an RFE is a Notice of Intent to Deny, the NOID. This is the notice that causes the most anxiety among applicants, and for good reason. When USCIS issues a NOID, the officer has already reviewed your case, evaluated the available evidence, and reached a preliminary conclusion that the application should be denied. You are being given an opportunity to respond, but you are responding to an officer who has already formed a negative view of your case. This is not the time for a routine document submission. This is the time for a focused, legally precise argument that directly confronts the specific grounds the officer has identified as the basis for denial. Responding to a NOID without qualified legal representation in most cases is a serious risk. Now let us address something that is causing very real hardship to immigrants in 2026, and that is processing times. USCIS processing times are extended across multiple application categories right now. This is not speculation. It is documented in the agency's own published data. The I-485 adjustment of status application can take anywhere from several months to well beyond a year, depending on the category and the processing location. Employment authorization document renewals have seen processing fluctuations that have left applicants unable to work legally while their renewals penned. Naturalization applications are experiencing extended timelines at many field offices, and the emotional and practical toll of this extended uncertainty on immigrants and their families is real and significant. Here is what you need to know about processing times that will save you anxiety and help you take effective action when action is actually warranted. USCIS considers a case outside normal processing time only when it exceeds the published processing time for that specific form at that specific service center or field office. If your case is within the published time frame, even if it feels agonizingly slow, routine inquiries to USCIS will not accelerate it. The contact center will provide a standard response. What you receive will not be new information. Save your energy and your anxiety for the moment it actually matters. Check the USCIS processing times page for your specific form and office. Know exactly where the line is, and when your case crosses that line, then take structured action. A formal online case inquiry, a congressional inquiry through your representative's office, or a more formal inquiry submitted by an immigration attorney. Let us talk about USCIS interviews, because for many applicants this is the moment of maximum anxiety in the entire process, and understanding what actually happens in an interview removes the fear and replaces it with preparation. USCIS conducts in-person interviews for adjustment of status cases, particularly family-based green card applications, and for naturalization. The interview is a direct evaluation. An officer will review your application, your documents, and your responses to their questions. They are looking for consistency. They are looking for honesty. They are looking for confirmation that the information submitted in your application is accurate and that you are who you say you are, with the relationship you claim to have or the employment history you documented. The most dangerous thing that happens in a USCIS interview is not a difficult question. It is an inconsistency between what is on your application and what you say verbally. Officers are trained to identify these inconsistencies, even small ones, a date recalled slightly differently, an address sequence that does not match your documents, a detail about your relationship that contradicts an earlier statement, can trigger heightened scrutiny and additional review. The preparation that protects you is reviewing your entire application file before your interview date, making sure you can speak accurately and comfortably about every single piece of information in that file, and bringing all original documents that correspond to copies already in the record. If your case involves any complexity, any prior immigration violations, any criminal history, any previous visa denials, any gaps in employment or residence, speak with a qualified immigration attorney before attending that interview, not after, before. Now the issue that runs underneath every single aspect of navigating USCIS successfully in 2026, and it is the issue that separates immigrants who protect their cases from those who unknowingly compromise them. USCIS operates inside a policy environment that changes continuously. The administration currently in office sets enforcement priorities and adjudication standards through policy directives. Agency leadership issues memoranda that change how specific application categories are evaluated. Federal court decisions can require USCIS to revise procedures that have been in place for years. Filing fees change, form versions are updated, and filing an outdated form version results in automatic rejection, regardless of how complete and correct the rest of your application is. In this environment, immigration information that is even 12 months old carries real risk if used without verification. There is one rule for navigating this reality. Official sources first, every single time. Every form you file must be downloaded directly from USCIS.gov immediately before you file it, not from a third-party website, not from a form you downloaded 6 months ago. The current version from the official source the day you file. Every set of instructions you follow must come from the current USCIS instructions for that specific form and filing date. Every processing time you cite when making decisions about your case must be verified on the USCIS processing times page for your specific form and your specific processing location. This is not excessive caution. This is the minimum standard of care that your immigration future deserves. The immigrants who navigate USCIS most successfully are not the ones who know the most. They are the ones who stay most current. Because in a system that changes as frequently and consequentially as US immigration, being 6 months behind on a policy update can cost you years. That is exactly why global immigration news exists and why staying connected to this channel matters for your immigration future. Subscribe right now if you have not already. Every week we break down USCIS policy developments, explain what visa bulletin movements mean for your category, cover changes in processing procedures, and translate official immigration announcements into clear, reliable guidance that you can actually use. Hit the notification bell so you never miss an update that could affect your case, and join our WhatsApp channel for real-time immigration alerts. When USCIS makes a significant announcement, when processing times shift dramatically, when a policy change takes effect that affects active cases, we push that information to our WhatsApp channel immediately. The link is in the description below. Here is what to carry forward from everything in this video. USCIS is a benefits agency, not an enforcement agency, and understanding this distinction removes fear-based decision-making that silently damages cases. USCIS and US Embassies are entirely separate. Know which agency governs your situation at every stage of your process. Your application is a legal argument, and every document either strengthens or weakens that argument. Completeness and consistency are not optional. An RFE requires a strategic, complete response, and a NOID requires qualified legal representation in most cases. Processing times are extended in 2026. Know your published benchmark and take structured action only when that benchmark is genuinely exceeded. USCIS interviews reward thorough preparation and punish inconsistency. Review your full application file before you walk into that room. And USCIS policy changes continuously. Official sources, current form versions, and verified current information are the only acceptable foundation for any immigration decision you make. Your future in the United States is too important to navigate on assumptions, outdated advice, or incomplete information. Build it on knowledge, protect it with preparation, and stay informed with sources you can trust. We will see you in the next video.